This is Steven from Industry Beef Channel. Young Thug was sentenced to time served as part of a sweeping case that originally included dozens of defendants. The rapper, whose given name is Jeffrey Williams, will be released from custody and have to serve 15 years on probation as part of the non-negotiated plea agreement. The case marked the longest in Georgia's history. In 2022, Williams was charged alongside more than 24 others under Georgia's sprawling Racketeer-Influenced and Corrupt Organizations Act, known as RICO. Prosecutors accused the rapper of leading a criminal street gang that committed murder and a slew of violent crimes in Atlanta dating back a decade. Williams has denied that he was the head of a criminal enterprise. They argued YSL, the acronym for the artist's label, Young Stoner Life Records, also stands for Young Slime Life, an Atlanta-based criminal street gang affiliated with the National Bloods gang. Prosecutors sought to prove Young Thug was the proclaimed leader of the YSL gang and was involved in crimes its members committed, including the 2015 fatal shooting of an alleged rival gang member. Young Thug had allegedly rented a car that was used by YSL members in the killing, prosecutors said. Several other defendants charged in the case, including rapper Gunna, took plea deals or had their cases severed from the trial. Young Thug had been one of 6 defendants on trial together. The rapper had been in jail since his May 2022 arrest. When the judge asked if he'd like to make a comment on Thursday, Williams said he takes full responsibility and apologized to his family before asking Fulton County Superior Court Judge Paige Reese Whitaker to let him go home. "I am a smart guy. I am a good guy. I really got a good heart," Williams told the judge as he stood before her. "I find myself in a lot of stuff because I was just nice or cool, you know, and I understand that you can't be that way when you reach a certain height because it could end badly." Williams added, "I've learned from my mistakes." He mentioned some of the free concerts he's hosted and money he's given to single parents and related charities. Before imposing a sentence, Whitaker told Williams, "I want you to try to be more of the solution and less of the problem." Let's check out this clip and let me know what y'all think in the comment section.
57, participation in criminal street gang activity. How do you plead?
I plead guilty.
As to count 58, violation of the Georgia Controlled Substances Act. How do you plead?
Guilty.
As to count 59, violation of the Georgia Controlled Substances Act. How do you plead?
Guilty.
As to count 60, violation of the Georgia Controlled Substances Act. How do you plead?
Guilty.
As to count 61, possession of a firearm during the commission of a felony. How do you plead?
Guilty.
And as to count 1, conspiracy to violate the Racketeer-Influenced and Corrupt Organizations Act. How do you plead?
No law.
As to count 56, participation in criminal street gang activity under the leadership charge. How do you plead?
No law.
I think you didn't ask about count 62.
As to count, thank you, Your Honor. As to count 62, possession of a machine gun. How do you plead?
Guilty.
Are you pleading guilty to the offenses you have indicated because you are in fact guilty of these charges?
Yes.
All right. Are your guilty pleas and your NOLO pleas freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today's date for a felony charge and 12 months from today's date you don't have a misdemeanor charge, but to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes.
Your Honor, also, you
have 30 days from today to file a direct appeal from this guilty plea and until the end of this term of court to file a motion seeking to withdraw the guilty plea, which does not mean it would be granted, but that's the time period, okay?
What's a direct appeal?
Well, you can talk to your attorneys more about it, but it would be up to one of the, like the Court of Appeals, I think is where this one would go. It's just the time periods.
And Your Honor, the state, in addition to the sentence we are asking that the court to impose,
okay,
we would also be asking the court to require or to forfeit, have defendant forfeit all of the property that has been seized and that is currently being held, that was found or recovered or taken from his home after it was searched on May 9th,
Do you have any kind of list of what that property is? I mean, I'm not familiar with what was seized.
And Your Honor, we're
We
not
do,
agreeing.
and
Oh, I mean, I assume y'all aren't agreeing to anything.
We're not
or you
agreeing
would
to that.
present it as a negotiated plea.
we're not. But we do have a list of the
All right.
property items.
Do you have it where available right now?
Yes, actually, would the court permit us to send it electronically?
Sure,
Because
that's fine. And then if that is not imposed as a condition, is it just get litigated as like any forfeiture matter?
Yeah, it's
Yeah,
a
it would be litigated later on.
It's
Yes.
a civil separate filing
Okay.
in this court. It's not related to the criminal
All right.
case. It's related case, but it's unrelated.
Understood.
This code section shall require as a special condition of the sentence that the person sentenced shall not knowingly have contact of any kind or character with any other member or associate of a criminal street gang, shall not participate in any criminal gang activity, and in cases involving a victim, shall not knowingly have contact of any kind or character with any such victim or any member of any such victim's family or household. So that is, and we've listed in our indictment the victims of the crimes, the overt acts that have been committed, and under the basic conspiracy law, those are the victims that we are naming. Your Honor, as this case has been tried and would continue to be tried until the state completed its case in chief, the evidence has shown that the defendant, throughout the time between 2013 to 2022, conspired with both indicted and unindicted co-conspirators to participate in the enterprise known as Young Slime Life, or YSL, through a pattern of racketeering activity. Throughout that time, multiple conspirators, both indicted and unindicted, and including the defendant, have committed overt acts intended to further the enterprise itself. With regard to the defendant, as far back, the evidence has shown, as 2013, the defendant, along with other YSL founding members, Walter Murphy, for one, committed an aggravated assault and armed robbery against a Derek Dotson. The court has heard evidence of that presented through Adrian Bean, who was a co-conspirator in that particular act.
Arrested on May 9th of 2022. There were other people in the house with the drugs and the guns. There are people whose the guns are in their names. They were going to come in court and claim the guns. Everybody else was doing as well, but Mr. Williams has entered a guilty plea. I'm not going back on that, but I just want you to know that this case is just wrong to do to somebody with no bond and to hold him hostage. He wants to, you may not do it. He's aware of that. He's aware of that. But the state offered him 15 years on probation. But they keep piling on these conditions. He just said, he made up his mind. He said, I'm just going to go with it. I got to get home. Judge may not let me home, but I'm not doing these conditions and admit that I'm the leader and I'm involved in the killing, and my music just promoted everybody to do it. He's not going to do that. So he did not do that. And that's how we wound up here. Arrested on May 9th of 2022.
I rep my life for real. For slimes, you know I kill. I shoot at your mammy, need to stand down. I up my stamina, take it to trial, get an appeal, take it to trial, pay for that casket, that's just if we whack 'em. YSL slimy and shady, watch me whack that bitch, pop 'em like assist, Glock with the assist. It also consisted of a song wherein Mr. Williams sang or rapped the lyrics, hey, this is that slime shit, that YSL shit, killing 12 shit, fuck a jail shit. I'm in the VIP, I got the pistol on my hip, fuck the police. You praying that you live, I'm praying that I hit, this that slime shit. 100 rounds in a Tahoe, I'm prepared to take them down. Got banana clips for all these ends acting monkey. This is that slime shit, this is that mob shit. Fuck the judge, YSL, this that mob life. Defendant Williams released a video on YouTube of a song wherein he states, "I shot at his mommy, now he no longer mentions me." Act like you want war and they gonna smoke you like a blunt. Another song, "I escaped every one of the licks because I was supposed to be rich. I don't care nothing about a cop. I'm just telling you how it is. I done did the robbing, I done did the jacking, now I'm full rapping." Gave the lawyer close to $2 million, he handles all the killing. We don't speak about shit on wax, it's all my business. We know to kill the biggest cats of all kittens.
Which is kind of crazy because there's been a whole pushback basically debating if rap music should be used against the rappers in court. Some people say it's art, but what happens when that art is actually real life? Now, just as I was making this video for you guys, Young Thug is officially coming home on 15 years of probation.
Lost on the court that the state, had they been able to come to agreement on certain special conditions, was willing to entirely dismiss the RICO count, was willing to entirely dismiss one of the gang counts, and was willing to entirely dismiss this, machine gun count. Was willing to give a sentence that permitted Mr. Williams to walk out of the door today, and therefore does not seem to be particularly worried that Mr. Williams, if on the streets, would be a danger to society. I'm taking that into consideration in crafting my sentence. And in permitting a no-low plea to the RICO count and one of the two gang counts, I would not be permitting the no-low to the one if you were not pleading guilty to at least one of them. But you are, and y'all admit a factual basis for the counts that you are pleading guilty to. I find there to be a factual basis for those counts, and for the remaining counts with which you are charged. I am going to impose a sentence, and I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution. On count one, the court sentence is 20 years to serve 5 years, commuted to time served, the balance of 15 years to be probated, and a $25,000 fine. On count two, the sentence is 5 years to serve, commuted to time served. That's the minimum sentence that's permitted on that count. It is required to be run consecutively. I'm going to run it consecutive to count one, but I am going to backload. Oh, I'm sorry, that is not commuted. That is 5 years to serve, and it's going to be run consecutively to count one, backloaded, by which I mean after you serve your 15 years of probation. If you have been successful on that probation, and I sincerely hope that you are, then at the end of that 15 years, I will commute the entire rest of any service portion of your sentence to time served. So I'll get to the end of it and give you the total sentence, but I'm also going to impose a $15,000 fine with regard to that count. Count 57, 20 years to serve 5, commuted to time served, the balance of 15 years probated, concurrent with count 1. Count 58, 10 years to serve 5, commuted to time served, balance probated, concurrent with count 1. 59, 5 years to serve, commuted to time served, concurrent with count 1. 60, 5 years to serve, commuted to time served, concurrent with count 1. Count 61, 5 years to serve, that is required to be also a consecutive sentence, so that's going to be run consecutively to count 56 and backloaded. Count 62, 10 years to serve, also required to be served consecutively, that's going to be consecutive to count 61, also backloaded. So essentially, the total sentence is 40 years to serve the first 5 years in prison, but commuted to the time that you have already served, followed by 15 years on probation. followed then by the backloaded 20 years, which can be served in custody and will be served in custody if you are not successful on your probation. If you are successful in completing your 15 years probation, that will be commuted to time served.